and our client is not able to leave it as the particulars do not inform on how it should be. It does not disclose who is the complainant. Is the complainant Mr. William Ruto, or is it D.L. Langat? And this is so important, Your Honor, and fundamentally important under Article 50, in the sense that we shall be requiring statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client and to this court. That's for you.
Your Honor, if I may.
Yes,
before you this afternoon, Asha Bashir.
And so that we don't take a lot of time on this.
Yes, I'm only raising one
Just
issue.
request that you do not repeat what the other
Yes. I'm only raising one issue. That the alleged complainant here is also not a witness. I am wondering how the two police officers, yet the complainant is not. So I humbly submit, like my seniors before me, that this is a faulty charge sheet and should not see the light of the day. Thank you, Your Honor.
Statement.
Yes, Your Honor.
I'm willing to do. An accused person.
Yes, Your Honor.
An accused person under Article 50.
Nancy. Yes, Mr. Chief.
Under Article 50 of the Constitution, an accused person has a right to be informed in sufficient detail of the charges proposed against him. Sufficient detail. What is presented as a charge sheet, if you look at the count 1, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post. Proceed to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Langat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Langat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil court. They sue for defamation. And criminal defamation is no longer applicable in our legal system. So that if the particulars presented before you,
Mr. Otieno,
yes.
we don't know whether there could be anybody in this room with blood pressure. So you need just to check on your voice so that you can
I'll be soft like a butterfly. I know men are still like a bee. Let me try to the butterfly on the I'll not inject. So, Your Honor, as for my disclosure, the particulars disclosed in the charge sheet speak to defamation, which is a civil wrong. The count in the charge sheet speaks to cyber harassment. There's disconnects in the two. So will Mr. Morara be required to respond to that charge sheet, Your Honor, should not be registered at this particular point. And the state can advise the complainant that in relation to reputation, the Chief Magistrate's Court Milimani exists, civil division. You can go there. In relation to cyber harassment, the complainant should come with better particulars, not these ones. So having dissected those two, the particulars of the charge and the count on the charge sheet, Your Honor should exercise your discretion and refuse to register this charge as presented before you, and direct that Mr. Morara to be set free forthwith, unless otherwise lawfully detained. So this is prejudicial at the outset. That's all.
Very kind permission.
just a moment. If I write everything, you might take the whole day.
That's what justice deserves. That's what it means.
That's the challenge with us lawyers. We respond even to what we don't know. We don't know what I was going to say. So I've been writing manually because you had not set up the gadgets. You didn't know this case of this nature was coming today. So now, just for your information, because now the gadgets have been set up, I will now not be writing. But please, when you speak, say your name at the beginning and use a microphone. Yes. So we'll have them transcripted.
You know, with the very kind permission, the matter is from my Morara, and I wish to guide the process forward. You know, I'll pick it up from where my learned senior Mr. Otieno left it, and urges to go straight to Article 25 of the Constitution on rights that cannot be limited. Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair. 5C of the Constitution. I'll, with humility, invite the court to read that together with provisions of Article 52B, which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be Your Honor, 52A, all what constitutes trial. Such that, Your Honor, as we stand before you this morning or afternoon, provision, Your Honor, or these are right, Your Honor, which cannot be limited. I invite court to find basis on those two, Your Honor,
criminal
Section
135. Institutional that an accused person to be in a position for under section if you are of the opinion and Your Honor will persuade you does not insufficient material disclose a case and I think I have said this before, if we continue at this rate, we will have to seriously expand this course. Because you don't know what it would mean is that any statement that a person can make under the free speech that is guaranteed in this country. It's the danger that we face with this kind of charges.